All right, good morning. This is um, Wednesday, January 19th, 2022. This is Senate Judiciary. This morning, we're taking up a bill introduced by Senators Sears and Campion dealing with medical monitoring. And I will start out with the landscape has changed somewhat in terms of medical monitoring. There was a settlement reached between the plaintiffs in Bennington and North Bennington and a little bit of Shaftesbury, which for those of you who don't know where those are, they're in southwestern Vermont. And the company responsible party was St. Gobain. The settlement includes around 6 million plus for medical monitoring for people who were impacted by the PFOA in their wells and were drinking over a period of time, drinking from those wells, water. Also, other parts of the settlement, which include property damage and soils and et cetera for other people who live in the area of contamination. And with full disclosure, that area of contamination includes my home here in North Bennington. So that I just want to make full disclosure that I may end up with a small amount of money as a result of the settlement, but that this bill has absolutely nothing to do with those. It only deals with folks who had wells that got contaminated at a certain level above, I think it's 20 parts per billion or million of contamination from the PFOA, from the former ChemFab plant in North Bennington, actually. So with that, and my full disclosure of my interest in this case, it is basically my constituents who were most impacted by this. We're happy that there was a settlement reached, and Emily Jocelyn is here. I will say that there are a few, other than a couple of words that are different in this bill. The bill pretty much mirrors Judge Crawford's settlement agreement in the case in North Bennington, Shaftesbury, and Bennington. So we may want to look at those words, and if we want to change those words, if it's important to mirror the settlement case in this area, fine with me. Warren Coleman, who in the past has opposed this bill, I spoke to him. He's not available today for testimony, but will be later in the week or next week. So with that, I'm going to turn it over to our able legislative counsel, Michael O'Grady, to walk us through the bill, and then we're going to hear from a few witnesses.
Good morning. This is Mike O'Grady with the Office of Legislative Counsel. As the chair just referenced, S113 grew out of the PFOA contamination discovered in Bennington, the subsequent citizen suit that was brought, the request for a remedy in that suit for medical monitoring. Medical monitoring is basically a program of medical tests for the purpose of early detection of signs or symptoms of a latent disease resulting from exposure to a hazardous material or toxic substance. There were concerns that the PFOA could lead to long-term health effects and diseases, and therefore medical monitoring was requested. Medical monitoring is recognized in other jurisdictions, federal and state jurisdiction, but had not been at that time recognized fully in the Second Circuit or in the state of Vermont. Consequently, you introduced S37 in the 2018-2019 legislative session. That passed both houses, but was vetoed by the governor. The governor's veto message did indicate that he would be willing to sign a future medical monitoring bill if certain words were included. But subsequent to that veto of S37, the governor vetoed it on June 17, 2019. On December 27, Judge Crawford in the class action against Saint-Gobain issued an order / opinion regarding how he was going to deal with the claims of medical monitoring. It's a very good decision. It's very thorough. And he set forth the factors that he would use in review of the medical monitoring claims in the class action. S113, as the chair referenced, tracks the Judge Crawford factors set forth in the December 27th order very, very closely. Again, as the chair referenced, there are a couple of words that are different. What I'm going to do is I'm going to walk through the bill, and then I'm going to put up a document that shows the differences side by side in the test from Judge Crawford's decision and from what's in S113. And then I have a small discussion of the distinctions between the two tests. And if you would prefer, I'll just dive right in and share my
I think
screen.
it's a good idea to dive right in.
Okay. So I'm going to share my screen. It will take me a minute. Can everyone see my screen?
Yes.
Yes.
Hello. Okay. All right. So S113 does two things. It establishes a cause of action for the remedy of medical monitoring for persons exposed to a proven toxic substance. It also provides that a person is liable for abating a release of a hazardous material if that person manufactured the hazardous material for commercial sale and they knew or should have known that the material presented a threat of harm to human health or the environment. So the first sections of the bill relate to establishing the cause, the action for remedy for medical monitoring. There's definitions, disease, any disease, illness, ailment, or adverse physiological or chemical change. It's serious if it has potential to cause death, disability, or chronic pain. Skip down to facility. Facility is important because the liability is going to attach to the owner or operator of a facility for the medical monitoring cause of action. And you will see that a facility shall not include land, structures, other appurtenances, and improvements owned by a municipality. So municipalities are largely exempt from liability from the medical monitoring cause of action. In addition, the cause of action is going to be against an owner or operator of a large facility where a release occurred. And a large facility is limited in several ways. First, there has to have been an activity that has a standard industrial classification code of 10 through 14, 20 through 39, 40 through 42, 44 through 46, or 49 is conducted. Now, I can provide you a list of those standard industrial classification codes, but it includes things like mining, coal mining, oil and gas extraction, tobacco products, textile mills, etc. Large facilities also defined by providing that it is where 10 or more full-time employees have been employed at any one time, or that is owned or operated by a person who, in all facilities or establishment that the person owns or controls, has, when aggregated, has employed 500 employees at any one time. And medical monitoring, I already described what this is. It's a program of medical tests for early detection of signs or symptoms of a latent disease resulting from exposure. Operator is the person who operates the facility. Owner is the person that owns the facility. A person is basically any legal entity that you can think of. And then you get to the definition of proven toxic substance. This is going to be one of the distinctions between the test used by Judge Crawford and the test and the cause of action established in S113. Judge Crawford provides that it's the cause of action exists when there is a exposure to a proven hazardous substance, but does not define what a hazardous substance is. S113 provides that there's a cause of action when there's exposure to a proven toxic substance, and then provides this definition. So it's any substance, mixture, or compound that may cause personal injury or disease, and that satisfies one or more of the following. It's listed on EPA's consolidated list of basically toxic substances under multiple regulatory programs. It is listed as a hazardous material under state law. Testing, recognized by the National Institute for Occupational Health and Safety, or US EPA, indicates that the substance poses acute or chronic health hazards. The Department of Health has issued a public health advisory for the substance. ANR has designated it a hazardous waste. And then finally, a bit of an umbrella that allows for demonstration to a judge in trial that exposure to the substance, mixture, or compound is shown by expert testimony to increase the risk of developing a serious latent disease. Now, the key provision here is what a proven toxic substance is not. It's not a pesticide when applied consistent with good practice and conformity with law, and it is not ammunition or components thereof, firearms, air rifles, discharge of firearms, or air rifles, or hunting or fishing equipment. And then last important definition is tortious conduct. The exposure must result from tortious conduct of the large facility owner or operator, and tortious conduct means negligence, trespass, nuisance, product liability, or common law liability for ultra hazardous or abnormally dangerous activity. So that then moves you into the substance of
Are there
the
any
creation of.
questions on the definitions before we move to the proven toxic substance? Okay.
Michael, could you just give a definition of something under the tortious conduct? You know, something a little clearer as to an example.
What constitutes tortious conduct?
Yes.
Negligence,
But
so negligence is one of the listed activities, and negligence is the person has a duty of care to manage the substance in a way that prevents its release, and maybe they are not careful in the management of it. They don't follow standards for the storage of the material. They don't monitor the material, and then the material is released and exposes other people.
thanks.
Moving on into 7202, this is the establishment of that cause of action. A person without a present injury, so you do not need an actual injury or disease at the time of the cause of action, shall have a cause of action for the remedy of medical monitoring against a person who is the owner or operator of the large facility in which a proven toxic substance was released if all of the following are demonstrated by a preponderance of the evidence. exposure at a rate significantly greater than the general population to a proven toxic substance as a result of tortious conduct of the defendant. As a result of the exposure, plaintiffs have suffered an increased risk of contracting a serious disease. The increased risk makes it medically necessary for the plaintiffs to undergo periodic medical examination different than that prescribed for the general population in the absence of exposure. And monitoring procedures exist that are reasonable in cost and safe for use. So that is the test, and we're going to look at that again in a minute in comparison to the test Judge Crawford used or set forth in his December 27, 2019 order.
So, Mr. Chair,
Yes,
there's a lot of noise from somewhere. I don't know if are other people hearing that? It's like somebody's microphone is being dragged through papers or something.
Papers,
it's
just,
probably me. I'm going to go to my other form.
Okay, I just wasn't sure where it was coming from.
I'm rattling papers trying to
I see.
keep track of it. So it's probably me. Let me know if that helps.
I don't hear it now.
Should I proceed?
Please do, Michael.
So if the cost of medical monitoring is awarded by a court orders the defendant to pay the award to a court-supervised medical monitoring program administered by one or more health professionals. And upon an award, the court shall award to the plaintiff reasonable attorney's fees and other litigation costs. And the chapter is the exclusive remedy for a person without a present injury to bring cause of action to seek medical monitoring, provided that that limitation in subdivision D1 does not preclude the pursuit of any other civil or injunctive remedy or defense available under statute. Moreover, the section does not increase the rights and remedies available under workers' compensation 21 VSA Chapter 9 to an employee who suffers a personal injury by accident arising out of the course of their employment, and workers' comp shall not limit the ability of that person to seek medical monitoring under the cause of action created by S-130.
I misspoke when I described just the property owners. It is former employees of the company. It would also be eligible.
Okay.
Whether or not they live in the area of contamination.
So that is the portions of the bill that create the cause of action for medical monitoring. Then you move into section 2, which is the portion of the bill which establishes liability for a manufacturer of a hazardous material that is released and the manufacturer knew or should have known that the material would be injurious to health or the environment. So 10 VSA 6615 is the current liability provision for releases of hazardous materials in the state. Some people call it the state circular liability provision. It's not quite that, but it is close. And it says subject to some of the defenses set forth in existing law. Following person shall be liable for abating a release or threatened release of a hazardous material. And so you'll see the existing current law, the owner or operator of the facility, any person who basically arranged for the disposal or treatment of the hazardous material, any person who transported it. And then you'll see there's a new subdivision 5 being added. Any person who manufactured the material for commercial sale and knew or should have known that the material presented a threat of harm to human health or the natural environment. So if you are a manufacturer of a material, you know the chemical in your product, when released to the environment, can bioaccumulate in fish or wildlife, or can depose to groundwater and then present a health risk to humans, you will be liable for the cost of cleaning up remediating that release of that hazardous material. And then there are some of the defenses. These are existing law. I just put them in there because they are referenced in the lead into this language. But there is a new defense for those people who are the manufacturers that are added in S113. A person shall not be liable under subdivision A5. So if they were the manufacturer and they knew or should have known of the effects of the material, provided that the person demonstrates that he or she provided an adequate warning of the harm posed by the hazardous material known or which should have been known at the time. So if they know about the potential harm of the material, but they're still manufacturing the material in a commercial product, they would escape liability for a release if they put on that product an adequate warning regarding the harm posed by the hazardous material to human health or the environment. And then there's some conforming changes in subdivision I, referencing that there's something called impleter in hazardous materials cases, because there's hazardous material releases. It's a joint and several liability. So the state can seek payment for remediation from all of the potential liable parties or just one of the liable parties. And whatever liable party is sought damages from by the state, that liable party can then sue any of the other potential liable parties. There's a policy concern there, is that when you sue certain entities, they then turn around and basically discharge their liability through suits against the other potentially liable persons. So for the purposes of the manufacturers of products where the manufacturer knew or should have known of the harmful effect to human health or the environment, this bill 113 is saying that there is no right of impleter, that that person is going to be liable for their damages, and they cannot sue another person to reduce the damages assessed against them for the release of the material.
Would this allow Saint-Gobain to sue DuPont? I believe was the manufacturer.
Well, this is if they are solely being liable because they were the manufacturer of this commercial product that they knew or should have known, then they wouldn't be able to sue. But Saint-Gobain is the owner. They're also the operator. DuPont was a previous owner and a previous operator. So they're not solely liable under this new category of hazardous material.
Michael, I think DuPont was the manufactured the Teflon, and then ChemFab, owned by Saint-Gobain eventually, was the one who put the material to use and in fiber and cloth, and built things like the Hewitt-Humphrey Dome in Minnesota.
Well, let's just focus on Saint-Gobain and ChemFab, because they would not solely be liable under subdivision A5 because they are the owner operator of the facility. So they could seek to plead, seek contribution from DuPont.
Okay, that's what I wanted to. Yeah, thank you.
And then there's a provision, section 3. This is regarding the application of that hazardous material, that new hazardous material liability. Notwithstanding the provisions in 1 VSA 214 that the statutes that are enacted are prospective in nature, not retroactive, the amendment in 6615A5 shall apply to any relevant release of a hazardous material, regardless of the date, including releases that occurred prior to the effective date of that new subdivision A5. So it is retroactive in effect. That is consistent with hazardous material release law almost every state and federal hazardous material release law applies retroactively. It's a policy decision. The courts have said that governments have a reasonable basis for applying it retroactively in order to ensure that the damages caused by hazardous materials releases are remediated and the liability is assigned to the persons responsible for that release. And then section 4, if the act takes effect on July 1, 2021, you could probably make that effective however you would like, including having the cause of action effective sooner or later, and the hazard material release sooner or later. So that's the bill.
Michael,
Yes.
I realize you're trying to achieve the retroactivity. Would we really put the effective date as 2021?
That actually, the bill was introduced last year.
No, understood. I was just wondering, then you said you could make it earlier or later.
Yep, you can change that date. You could make it a passage. You could make it.
Well, in other words, I've never seen an effective date that was prior to the date of signing. Is that what you're suggesting?
No, I'm not suggesting. I'm just saying that you can move that date, and you often, almost every year in the tax bill, have effective dates that are prior to the actual signing date of a bill, because you have to implement that tax change on a calendar basis.
Yep.
And so you often move that date prior to. So you can do it with other provisions as well.
Okay. Thanks.
So now I am going to stop the share, and I'm going to share another document.
This is very helpful. By the way, these documents, this document's available on our website. Committee web page. I guess we call it the committee web page.
Yeah.
So what this document really does is to compare the medical monitoring elements in the Judge Crawford December 2019 order and S-113. I gave a little background about how Judge Crawford developed the test he did. He relied on two of the seminal cases in medical monitoring, the Paley case and the Bauer case from Pennsylvania and West Virginia, respectively. And then he set forth his elements that he was going to use. So first, there needs to be exposure to a proven hazardous substance, whereas S-113 has exposure to a proven toxic substance. So that's one major distinction. The exposure has to be a result of the tortious conduct of the defendant, and that's the same in Judge Crawford's test in S-113. There needs to be exposure at a rate significantly greater than the general population. That's the same in both tests. As a proximate result of the exposure, plaintiffs have suffered an increased risk of contracting a serious disease, whereas under 113, it's as a result. So it doesn't have to be the proximate result, the direct result. It just has to be a result of the exposure. Plaintiffs have suffered an increased risk of contracting a serious disease. And then the increased risk makes it medically necessary for the plaintiffs to undergo periodic medical examination different from that prescribed for the general population in the absence of exposure. Same under both tests. And then the monitoring procedures exist, which are reasonable in cost and safe for use. Again, same underneath both tests.
Can we go back to the proximate result versus as a result?
Mm-hmm.
What does proximate do?
It's proximate means it's a direct result. It refines that causation element a little bit more. Frankly, I think if you were going to be litigators for this, for the fast seeking medical monitoring, you would be able to show the approximate result under either test. But it does give a little bit of traction to say that the result, the exposure, did not increase the risk of contracting disease. It's a slight distinction, but it is a distinction.
Thank you.
Michael, can I ask a question? Exposure at a rate significantly greater than the general population, is that handled on a case-by-case basis? Or is there some mechanism by which the courts are determining what significantly greater actually means?
So it's a great question, Senator Benning. One of the distinctions I wanted to make about these tests, both of them, is that they're going to be incredibly fact-based and specific to each exposure, because you're dealing with different materials, you're dealing with different levels and types of exposure, scope of exposure, duration of exposure. You're dealing with different classes, how they were exposed. So it's going to be, it's an incredibly fact-based, expert testimony type of case. So there isn't any default that a court necessarily can use. They're going to have to look at the specific facts of each exposure and each release.
So the determination, given a given fact pattern, one judge could decide it is, and one judge could decide it's not. Is there no way to have uniformity about what that term, I guess I'm looking for some kind of guidelines. I don't know if there's any history in the civil courts about that particular phrase.
Well, honestly, there's having practiced environmental law for a while, there's many ways that you could try to show that that the exposure is increased, is different from, say, the general population.
Okay.
You might even be able to forum shop a little bit, where in some states the background level exposures are going to be higher or lower depending on what you're looking for. And so,
Yeah, it was ultimately that forum shopping possibility that just piqued my curiosity. But I don't practice in this area, so I appreciate the answer.
So I'll tell you this: the one of the seminal cases in this field is the Paley Rail Yard case. I grew up next to the Paley Rail Yard, like literally like 5 miles away from the Paley Rail Yard. My dad's office was maybe 300 yards from the Paley Rail Yard, and the level of PCBs in the soil throughout that area, I mean, they're just there wherever you go. And so they had to look at what the background exposure was relevant to what the exposure was of the class of plaintiffs bringing the claim against the rail yard. So it really depends on where you are.
Right. Okay, appreciate the answer. Somebody's dragging papers across their microphone again.
I think it's Mike.
I'm sorry, it might be my microphone.
Yeah,
How's that? Is that better?
that is better.
Yes.
Okay. So then I just want to talk a little bit about some of the key differences. So one is the hazardous substance versus toxic substance. Judge Crawford didn't define what a hazardous substance is, so that would then become an issue at litigation, whether or not what the person was exposed to, the class was exposed to, is actually hazardous. Whereas S13 lists those substances that are going to be considered a proven toxic substance. And we went through that list. They're either on EPA's list, consolidated list, they're designated hazardous material by the state, they're designated hazardous waste by the state. They are considered by NIOSH or EPA to have the characteristics of the hazardous material. The Department of Health has issued a public health advisory for them, or expert testimony is used to show that the exposure increases the risk of developing latent disease. So that's probably, that is the major difference between the two tests, between Crawford's test and the test in 113. The other major difference is that under Judge Crawford's test, it's any person who exposed the plaintiff to a hazardous substance. So it doesn't have to be a large facility. It could be brought against a municipality, against any person who exposed the plaintiff to the hazardous material, hazardous substance. Whereas in 113, the liability, the potential cause of action is against a large facility owner or operator. So it has to be operating in one of those standard industrial code classifications. And they had to have had the certain number of employees, or the entity as a whole employed across all of their facilities and establishments, 500 employees or more at any one time. So that, and under S-113, municipalities are not subject to the cause of action. So that's yes.
Question. I think I may be incorrect, but in some places, say states or even in Vermont, regional technical centers have used certain compounds and other things. I know there was some PCBs at one. And I'm curious if under the Crawford decision, that regional technical center might be subject to suit, but under 113, it wouldn't be.
I think that would likely be, yes, I think that the regional technical center is subject to potential liability under Judge Crawford's decision, whereas under 113, municipalities are exempt and school districts are municipalities, and that regional technical center is, I think there's only one that's independent, right?
No,
I think there's three.
Yeah.
Okay.
But I think they would fall under the same. I believe they have their own charters.
Could I ask
I don't know.
a follow-up to that?
Senator White, yes.
So in the same vein, then, a municipality that has a fire department that used, because it was what they used at the time, fire retardant materials to either at the fire station or on a particular fire, they would also be liable here?
No, they would not be liable under 113. They potentially could be liable under Judge Crawford's test.
Right. They would. Yeah. Okay. Thank you. That's what I wondered.
Okay. Thank you, Michael. I think that's really important distinction between the two.
Then the last part of that document is just what Judge Crawford's test means for you. Effectively, it's not binding on state courts or the state legislature. You have, because you're the ultimate policymaker under the Vermont Constitution for the state, you can accept or reject or conflict with the Crawford decision if you like.
One further question about that. Does that mean that Crawford's decision is part of a settlement? So he approved the settlement, but is his decision got the force of law behind it on the federal level? I mean, unless somebody challenged it.
So I wouldn't say that his decision was part of the settlement. I would say that his decision informed the settlement. It basically inspired the settlement because he telegraphed that he was likely going to, if it was going to go to trial, etc., that he was likely going to find medical monitoring as an award. It's not binding on state courts. That's the first bullet I wanted to say. His order from December of 2019, it's not binding. It's instructive, but it would not be binding on state courts. Now, in other federal courts, they would probably look to that order, and although it's not controlling, they would look to it for instruction as well. It has a little bit more precedential effect in the federal courts than it does in state courts.
Thank you. This is really helpful. I think it gives us, a narrow places to look at what, some of our witnesses may be or may not be concerned with. And some of the folks who want to pick and choose what parts of Crawford to adopt and what parts not to adopt.
Okay, I'm going to stop sharing my screen now.
Okay. Thank you. Are there any other questions for Michael? Michael, I can't tell you how helpful this was. And actually, I have one other question that maybe John Grosvenor or Emily Jostin can answer, and that is the amount of the overall settlement was in the $30 million range, but only about $6 million was for medical monitoring. And I'm curious about how that got divvied up or why. Now, it seems like a relatively small amount. So as we were talking about this bill a couple of years ago when the governor vetoed it, the sky was going to fall and manufacturers wouldn't come here and all of that. And so I'd like to a little bit focus on the amount of that settlement as well. And maybe folks can help me with that. It was referred, I think it was seen as anti-business by some. So.
I would defer to Emily on that, Senator. I know she can answer that question.
I'd like to kind of focus on the actual amount as compared to the rest of the settlement. Giving people comfort to know that they can get tested and that the cost will be on St. Gobain's or on the settlement, not on their own personal health insurance or their accounts. But that's one of the things I was surprised at when I saw the final settlement, the amounts.
So, Senator, would it be helpful? I think I was going to test. Yeah, I'm John. For the record, it's John Groveman. If Mike is finished, I'm happy to provide.
Yeah, I was check. I don't think the committee has any further questions for Michael. Is that everybody said? I mean, it was a great. Thank you for the preparation of that. It was really clear. So, thank you, Mike. John, you're up next.
Okay. Thank you, Senator. So I'm just going to provide a little background and walk through VNRC's view of this version of the bill. And what Michael just did is incredibly helpful, and you'll see a lot of overlap. So for the record, my name is John Groveman. I'm the Policy and Water Program Director for the Vermont Natural Resources Council. As I think all of you know, VNRC, we're Vermont's largest in-state environmental advocacy group. We have about 5,000 members throughout the state. We have different program areas. One relates to water, and we do a lot of work on toxic chemicals. My background that informs this testimony, just for context, is I am a former A&R general counsel. I was a former general counsel for VNRC. I've taught for about 7 years environmental law at Norwich University, including a section of my course on torts and civil liability, which these issues fall under. And I really appreciate this opportunity to testify in S-113, which VNRC supports. So as I know you're aware, and as Michael went over with you, this is the third time this committee's taken up a bill, and hopefully it's the third time that the committee will pass a bill that would allow people contaminated by the release of toxic chemicals to pursue costs of medical monitoring. I'm not going to belabor these points because this is my third time testifying on a bill, but each time I've done it, I just provided for the record kind of where this proposal came from. And it was first noted in Vermont as an issue to be addressed after the contamination of PFAS in the Bennington area. The legislature passed Act 154, created a working group of a variety of stakeholders, industries, academics from UVM, and environmental groups. VNRC was part of that. There are other environmental groups. And there was a number of recommendations that came out of that work group that was basically saying, look what's happened in Bennington. Clearly, there are vulnerabilities that Vermonters have to toxic chemicals. What can we do to implement policies to better protect Vermonters? One of those policies was to allow for a cause of action for medical monitoring. So that's where it comes from. I'll probably submit, just for the record, the report again, just so you have it as part of your record to Peggy after I testify. So as Michael said, about 16 states, he said other states, by my count, it's about 16 states through case precedent allow a person to attempt to recover costs of medical monitoring when a person is exposed to a known toxic chemical that's created a risk of the person contracting a disease. As you've heard during your previous review of this issue, with what this is really all about is with toxic chemical exposure, often a person can have high levels of exposure and high levels of a chemical in their body without initially developing a disease. However, the issue is with medical monitoring that the exposure increases the risk of a person eventually getting sick and contracting a disease, and therefore you need to go get regular medical attention, much more frequent than you usually would, to be monitored to see if that exposure has manifested itself into a full-blown illness. And the medical monitoring allows for early intervention to treat the disease and provide the person with the best chance of recovery. So that's what we're talking about, just kind of pulling back from the legal issues and what medical monitoring is and why it's important. So, what are some of the underlying legal issues with medical monitoring? Why is this even so hotly debated? Why is this the third time that your committee is taking up this bill and it's been vetoed by the governor twice? So the underlying legal issue, in my view, the most significant one is that in states where medical monitoring is allowed as a cause of action, basically a decision has been made about when somebody is harmed. Again, in my past testimony on this issue, I've submitted a policy paper prepared by Professor Ken Rummel from Vermont Law School. I will submit that again for the record. And basically what Professor Rummel, goes over is that, the underlying legal issue is under tort law or civil liability law, is a person deemed to be harmed when exposed to the toxic chemical that was released, so that exposure increased the risk of getting sick, or is somebody deemed harmed, legally harmed, when you actually become sick? So in most states in the country, under tort law and civil liability law, a person is deemed sick when they actually contract a disease, not when they get to the exposure. And so therefore, the person is not allowed to go to court to seek costs for medical monitoring. And that's really the issue. And that was the issue that Judge Crawford was asked to grapple with in the liability case brought as a result of the PFAS contamination in the Bennington area. And so kind of jumping off what Michael said, so that case, when it was recently settled, my view of it, and Emily will speak to this with more clarity than me as the lawyer on the case, but the settlement did include the payment for medical monitoring, but it does not set legal precedent in federal court or state court. I think Michael just said that it's instructive and it's more instructive on the federal level. I agree with that, but it's not legally binding. It's not a final decision that establishes medical monitoring even in federal courts as a cause of action and a remedy that could be sought by Vermonters. Absolutely, when we see again other instances of releases of chemicals that expose people, that create the need for medical monitoring, and if there's a lawsuit, no doubt Judge Crawford's decision will be cited. No doubt the federal courts in Vermont will look at it. But if there wasn't a settlement, Judge Crawford's decision could have been appealed. And I believe it probably would have been appealed. That would be another way the case could have gone. I think, but for the really excellent advocacy from Emily and her colleagues. So I still think it's very important for your committee and the legislature to clarify that Vermonters in the situation where they need medical monitoring because of the release of toxic chemicals, that there's no question that they could pursue costs for medical monitoring. What it would really do is just take out one argument that whoever released the chemical could make to try to obstruct and delay Vermonters who seeking medical monitoring from being able to recover those costs. And I'm sure that if the legislature doesn't clarify that medical monitoring cause of action exists in Vermont, it will be fully litigated. And how can I say with such certainty that if you don't pass this bill, this issue will still be litigated? And Emily will again speak to this, I think, more articulately than I, but this is how toxic liability cases go. When chemicals are released, they're usually released by entities that have significant resources, significantly more resources than the victims of toxic pollution. And they use all of their available legal tools to basically say, I'm not responsible. I shouldn't have to pay for this. I shouldn't have to pay for that. And if there's no cause of action for medical monitoring that's clear, there's no question that it'll be a legal issue raised in the case and it'll be litigated. And at the very least, it will delay Vermonters from being able to recover those costs. And maybe it will be an obstacle from Vermonters ever recovering those costs. So really all we're asking for in S113 is to just take that one issue and just make it clear. And there'll be plenty of other issues litigated as part of any of these toxic liability cases. But let's not litigate whether Vermonters can pursue the cost of medical monitoring. Let's take that one issue off the table so it won't be used to obstruct or delay. If Vermonters could meet the very, I think, fair and strict test that is in S113. So let's talk about the test in S113. I'll try to do it from the 30,000 foot point of view because Michael just did such a good job going through it. So the test in S37, the last iteration of this bill, the governor in his veto message objected to the test, saying it was out of step with tests created by the other courts in the country that have allowed for this medical monitoring cause of action. I just want to be clear that VNRC does not agree with the governor's position on that and the opponents of the previous medical monitoring bills. The other tests for medical monitoring vary. There were some that were really different than the test in S37. There were some that were similar but not identical. And in my research on this, all the other tests in all the other states were kind of came out of what the facts of the cases were. What were the litigants focused on? And what we were trying to do in previous versions of this medical monitoring bills was sometimes in creating those tests, there were some language used that I think inadvertently allowed for litigants to obstruct and delay and not really get to the heart of whether medical monitoring should be awarded, but really could bog down a case. So we were trying to basically streamline the test, make it fair, but remove elements that would be really unfair to victims of toxic pollution. Having said that, and having the benefit of some time, looking at the Crawford test in 113, seeing that what we really need to do to get a bill to go forward is to have language that the governor feels is aligned with other tests. And I don't know how a bill couldn't be aligned better than a test that was referenced in a preliminary ruling by a Vermont federal court judge. We think at VNRC that aligning 113 with that test that Judge Crawford, set out is still going to help Vermonters, and so we support it. It will still give victims of toxic pollution a fair chance to recover medical monitoring costs and take the issue off the table, as to whether that it's a remedy that can even be sought.
But are you suggesting that we follow the Crawford test, for example, using the term proven hazardous substance versus proven toxic substance?
No, I'm not. I'm saying
you're going to get. I'm jumping ahead of your testimony.
Yeah.
I'm sorry.
That's okay. No, I'm saying this test in S113. I'm saying we support S113 as written, even though we don't love every part of it, because we think it will benefit Vermonters and something that I think it was designed to address the governor's concern and concerns that opponents have raised. As Michael O'Grady said, I identified the same two differences in the test. I think the difference between toxic substance and hazardous substance between the Crawford test and 113 is because we define proven toxic substance. It's something that I've said every time I've testified on these issues over the years, is that one of the real benefits of doing this in statute is we could define toxic substance. As Michael just said, in courts, there are no definitions, right? So we're actually providing more certainty in 113 than Judge Crawford provides, or any court would, because courts don't issue those sort of definitions. And I support that certainty. We support certainty. We think everyone should know the rules of the game. So no, I actually support that part of that difference between the Crawford test and 113. And then the other difference in the test, as Michael noted, is whether you have to have, whether the need for medical monitoring is the result, which is what 113 says, or the proximate result, which is what the Crawford test says. I don't know if there's I don't think there's a significant difference in that language, but I would argue that result, which is the 113 test, is actually probably harder to meet because, proximate result means that you have to show that there is a connection. It doesn't have to be direct. Result is more direct connection. So, but even with that, because I think the bill would help Vermonters, and VNRC does, we support the bill as written. I really want to make the point really clearly that it just boggles my mind that opponents of a bill to create a medical monitoring action, has said things like, well, we don't want it. Let's not have a statute. Let's let the courts decide. There are provisions in S113 that are tailored to Vermont based on testimony that your committee has heard over the years that will never end up in a court decision that was not in Judge Crawford's decision. For example, as Michael noted, there's a carve out for pesticides if pesticides are applied in accordance with the law. There's a carve out for municipalities. There's a carve out for shooting ranges. There's a limit on who could be, who you could seek medical monitoring costs from. You have to be a large facility. Under Judge Crawford's decision and any of the other court decisions throughout the country, there's no limit. You know, we've heard concerns in your committee over the last few years about mom and pops being, small businesses being sued for medical monitoring. This basically addresses that. And this statute and this bill gives you the opportunity to respond to those concerns that you've heard and tailor a cause of action that will help Vermonters who are victims of toxic pollution, but address the policy issues that you've heard. No court will do that. Judge Crawford's decision didn't do that. So for the life of me, I just can't understand why people would say, don't do this. Don't put in a fair provision that'll help Vermonters. Let's see what the courts do, you know, over the years, except that it's just a long time to go through the courts and get a decision. And maybe once we have a clear precedent setting decision in courts, maybe someone would come to the legislature and say, well, now we need a bill limiting that decision. I really don't know, but it makes absolutely no sense to me. And, you know, at the end of the day, you know, VNRC would prefer a bill that didn't have carve outs for pesticides and issues like that. But we support 113 as written because we've been through this for several years. If this doesn't address the concerns raised by the governor and others, I don't know what will. I think the bill is balanced as it is. So I would be very wary about people coming in trying to weaken a bill that's already, you know, is a compromise in and of itself. But we support it. It's just past time to pass this bill and to sign it into law. So the last thing I want to say is the other part of the bill is very important. The other part of the bill that Michael Grady went over about liability, being able to get to the manufacturers of these chemicals. I want to focus on, and in previous, this provision was in the previous iteration of this bill. And I believe the administration supported it. And we agree with the administration. This is very important provision. What we're finding, you know, the PFAS chemicals are just the best example of this, sadly, is that, you know, we're finding PFAS at significant levels in our wastewater facilities, in our water supply facilities. It costs money to treat wastewater to get PFAS out of it so it doesn't get discharged to public waters. It costs money to treat water supplies, drinking water supplies, so people aren't drinking water contaminated with PFAS. And this bill would let state of Vermont go after the manufacturer of these chemicals and hold them accountable for the significant costs that we are going to have to pay over time to basically get these chemicals out of our wastewater and water supply systems. So it's a very important provision. You can talk to the Attorney General's office. I'm sure that they would like to have this tool in their toolbox. And Vermont is not going to be able to afford to deal with these issues of chemical contamination, especially PFAS, given how prevalent it is if we don't have these legal tools. So that's my testimony. Happy to answer any questions. And Emily Attorney Josselson is going to testify next, and she can answer questions about the settlement and other issues.
Yeah, I don't know if the committee has any questions. I think both you and Michael have really cleared up a lot of my concerns about the differences between Crawford and 113. I guess, I want to, we learned a lot from Hoosick Falls, New York, which is 8 miles away, which also had a Saint-Gobain plant. And their water supply was contaminated, the village water supply. And for years, they had a high incidence of certain cancers. Even the doctor in that community came down with that cancer. How would the two, either the Crawford or the the settlement impact, that knowledge from other places? That's, I guess, what I'm concerned with. To making sure that the difference between proven toxic, proven hazardous substance. So we knew that from there. They haven't even settled yet there, or even Merrimack, New Hampshire, by the way, two other places where these suits are going on. I'm just curious, and maybe Emily would be the better person to answer that. But would either one of those change what we knew? I mean, what we could guess. I mean, I'm not a lawyer. I just kind of common sense tells me, and actually my constituents were calling about, what they found and whose it falls. Is it here? And that's how it was really discovered. We called the Shumlin administration and they came down and tested. And as a result of those tests, we discovered that Bennington and North Bennington, many people's wells, but that our village and town water supplies weren't impacted. So,
Yeah, if I understand your question, and Emily, I'm sure will address it as well. But so I think, proven toxic chemical, I think it's a really good definition that we worked out over several years, where it provides a lot of certainty because is a chemical on the list. But as I think what you're getting at is PFAS wasn't on any of the lists when these contamination occurred. And there is a part of the definition of proven toxic chemical is if an expert could come in based on factors and prove that a chemical is harmful. And so it does allow for that, a chemical that's not on any of these lists, someone to come in and say, we've been exposed to it and we need to receive costs for medical monitoring. But it provides even some sideboards around that and some guidance, I think, to the attorneys in terms of what they have to argue. So I think, and that definition was worked over in the House Judiciary Committee, and the bill itself contains, I'll address these issues only if there are any opponents of the bill, but if people raise questions about them. We worked through a lot of issues last time that were raised in the House Judiciary Committee, and between your two committees, that's the bill. That's what 113 is. It's sort of a refinement of the test based on two different times of running this through the Senate and the House, and defining proven toxic substance is one of those issues. Actually, just one other, I remember I wanted to address Senator Benning's question a little bit on on how courts deal with, what's a significant greater risk. And I just wanted to point out that I agree with Mike O'Grady that it really is fact-based, and whether you have a statute or a court, like in the Crawford test, it's just always going to be litigated, and you're going to have the facts of every case are just going to determine what is significantly greater. And so I think that that's just the nature of this sort of civil liability, that you have to kind of work those through the system.
thank you. Our next witness is Emily Jocelyn, and I'm wondering if we take a very short break right now and then come back, since to give the committee a short break, and if it's okay with Emily, if we came back at 10:30.